A few weeks ago, I talked about revocable living trusts, which are a core part of many estate plans. They are designed to make the distribution of your assets to loved ones as smooth, cost-effective, and hassle-free as possible. But while revocable living trusts offer many benefits, they also have some often overlooked downsides. For example, they do not provide asset protection while you're alive and offer only limited estate tax benefits. Without careful planning, your hard-earned wealth could end up in the wrong hands, get tangled up in little battles, or shrink because of unnecessary taxes. In today's video, I'll explore how revocable living sub-trusts can fill these gaps to protect your legacy from creditors and lawsuits while allowing it to grow safely for your loved ones. With the right structure, you can ensure that your wealth passes to heirs as intended and continues to benefit future generations. To better understand what a sub-trust is, imagine a family with a revocable living trust. Mom and dad have worked hard to ensure their kids and grandkids are well taken care of. When dad passes away, mom is left to manage the estate. Without sub-trusts, assets could get mixed up, making it hard to track of who gets what. Even worse, what if mom remarries? Or what if she has a lot of debt and faces debt collectors? Or what if one child is bad with money or another has special needs? That's where sub-trusts come in. Think of them as mini trusts created within the primary trust, each with its own specific rules, purpose, and beneficiaries, almost like a personalized playbook for handling assets based on each family member's unique situation. When the main revocable living trust becomes irrevocable, usually upon the grantor's death, these sub-trusts are activated, ensuring assets are distributed and managed exactly as intended. Essentially, sub-trusts serve as a safety net and protect the inheritance from being misused or lost to outside forces like ex-spouses or creditors. One of the top priorities for many people who are looking to leave their legacy is asset protection from creditors and lawsuits. As I mentioned earlier, revocable living trusts do not offer much help here, but sub-trusts are ideal for this purpose and can safeguard assets from the creditors of your beneficiaries, children, or even your spouse. This protection kicks in because after your death, a revocable trust becomes irrevocable, making the assets more secure against lawsuits and creditor claims. For example, if your child works in a high-risk profession like medicine, where malpractice suits are a possibility, you can set up a specific sub-trust to protect the inheritance from potential creditors. Another strategy to protect your assets is to establish separate revocable living trusts for each spouse instead of a joint revocable living trust. While joint trusts are simpler to manage, they remain revocable after the first spouse's death, leaving assets vulnerable to the surviving spouse's creditors. With separate revocable living trusts, the deceased spouse's trust becomes an irrevocable sub-trust, offering better protection from creditor claims, even if the surviving spouse's trust remains revocable. You can also let the beneficiary act as the trustee of their own sub-trust. Although the beneficiary handles the distribution and investments, the trust remains irrevocable, which means creditors still cannot access those assets. This protection exists thanks to the HAMS standard, which limits the use of assets for the purpose of health, education, maintenance, and support. As long as these rules are followed, asset protection is maintained, even with the beneficiary in control. Alternatively, you can appoint an independent trustee, someone unrelated to you, to step in when needed. For example, if the surviving spouse is both trustee and beneficiary, and the distribution falls outside of the HAMS standard, they may worry about potential liability. In this case, they can appoint an independent trustee, if the trust documents permit so, to handle that specific distribution, reducing personal risk and maintaining asset protection. Sub-trusts can help minimize estate taxes, especially for married couples. For example, sub-trusts like AB trusts or QT trusts can strategically divide the estate to minimize taxes, allowing more to be passed on to the next generation. Another big advantage of a sub-trust is its ability to help preserve wealth across multiple generations. Many people usually leave assets outright to their kids or spouse because they think it's the most simplest and most efficient option. But it often results in losing control because the beneficiary can literally use the funds however they choose, often redirecting them outside the family. Sub-trusts prevent this by offering more structure. You can specify when a beneficiary can serve as its own trustee or appoint a co-trustee, like a corporate trustee, to manage investments and ensure the safety of the assets for the future generations. This balances family involvement with professional oversight. Another crucial yet often overlooked part of generational wealth planning is the power of appointment in a trust. Parents typically include this provision to give their children some flexibility to make outright distributions if unexpected needs or disabilities arise. However, depending on its type and how it's written, the power of appointment can override your original intentions and let beneficiaries redirect asset distributions to others, including non-family members. If you want the wealth to stay in the family, make sure the power is clearly defined to prevent unintended changes. This way, your legacy stays secure for future generations. This might sound dramatic, but sub-trusts let you rule from the grave. If you are worried your kids might waste the inheritance and quit working because of the windfall, you can set limits on how they access the funds, allowing distributions only for health, education, maintenance, and support. This way, you protect the rest of the assets so they continue to grow and benefit future generations. If your goal is to eventually distribute the assets and terminate the trust, you can set up a sub-trust to distribute funds gradually as your children get older, reducing the risk of a sudden windfall that could be harmful. For example, you could direct the trustee to give out 1/3 at age 30, another third at age 40, and the rest at 45. This approach is ideal if your children are not financially mature yet and could potentially misuse a large inheritance. For blended families, you can include a provision requiring the trustee to consider the beneficiary's other resources first. This ensures a surviving spouse does not deplete the funds, leaving nothing for your children. By structuring the trust thoughtfully, you protect your legacy and support your family's long-term financial well-being. Another major benefit of sub-trusts is how they can support beneficiaries with disabilities. Properly structured, these trusts provide financial assistance without disqualifying the beneficiary from government benefits like Medicaid or SSI. This can apply not only to children, but also to spouses who may require long-term care in the future. To be effective, this planning needs to happen early, before any long-term care needs arise due to Medicaid's look-back rules. A great option is to include a standby supplemental needs trust in the main document and allow the trustee to have the discretion to direct assets there if needed. Alternatively, you may include a provision that lets an independent trustee to step in to set up a separate trust if a beneficiary's circumstances change and they need government support. To summarize, sub-trusts are incredibly versatile tools that help families balance tax efficiency, asset protection, and financial security for all beneficiaries, no matter their unique needs. Another great thing about sub-trusts is that they can be tailored to fit nearly any situation. In this video, I will highlight a few common types without delving too deeply into the specifics. But if there is a specific sub-trust you'd like me to cover in more detail in the future, please let me know in a comment below. A marital trust is a spouse protection sub-trust. It's created to support a surviving spouse, giving them access to income or principal, but with a catch. It includes provisions to ensure that the remaining assets are distributed according to the grantor's wishes after the surviving spouse's death, preventing them from being diverted outside the family. A family trust holds assets for the benefit of children and grandchildren, with rules for distribution, like only when they turn a certain age or meet a milestone such as finishing college. A disclaimer trust is usually set up when the surviving spouse decides they don't need the entire inheritance. They can disclaim or pass some assets into the sub-trust where it can be protected from taxes or preserved for future generations. A special needs trust, also called a supplemental needs trust, is crucial for families with special needs children or dependents. Setting up a special needs sub-trust allows to provide extra financial support for loved ones without jeopardizing their eligibility for government benefits. Instead of giving them money outright, the trust holds and distributes funds in a way that keeps them qualified for Medicaid, SSI, or other assistance programs. A spendthrift trust is used when there is a beneficiary who's not great at managing money. It restricts how much money they receive and under what conditions, protecting the funds from being wasted or seized by creditors. Even with all these benefits, sub-trust can backfire if not set up correctly. For example, if your sub-trust instructions are not clear, it can lead to disputes and even court involvement. Another pitfall is picking up the wrong trustee, which can result in mismanagement or conflicts of interest. In addition to that, As family circumstances change, new marriages, divorces, birth, death, you need to update your sub-trusts accordingly. Many people forget to do that, and this can lead to serious issues in the future. Creating a revocable living trust is a great start, but without sub-trust, you are possibly missing out on some of the strongest tools for protecting your legacy. Whether it's tax efficiency, asset protection, or simply making sure your wishes are followed, sub-trusts are the guardrails that keep your estate plan on track. If you want your plan to fully reflect your wishes and adapt to life's complexities, sub-trusts are the way to go. That's all for today. If you found this video helpful, don't forget to hit the thumbs up and subscribe to my channel. And if you'd like us to take a closer look at your estate planning goals and help you create a solid plan for leaving a lasting legacy, feel free to schedule a complimentary estate clarity meeting by using the link below or visiting us at www.lestna.com. Thanks for watching.